Hello everyone, I'm Kaylee Anderson, Deputy Public Defender with Tulare County, and today we're going to talk about defending Penal Code Section 647F, public intoxication. There are 5 practice tips here, as the PowerPoint implies. The first 4 are going to be kind of general, kind of common lawyer strategies that you might expect from any particular crime that you might want to defend. Useful things to know, common pitfalls, good strategies, things like that. And then the 5th one is a dark, secret, forbidden technique. That's not forbidden. It's a rarely seen defense, but one that's extremely useful and applies in a very, very large number of cases to just completely get an acquittal. And I mean, it's basically getting them off on a technicality, as cops and prosecutors are so fond of saying. But it's a very useful defense, so stay tuned for that one. But first, we'll get through the first 4 tips, and before we do anything, let's start with the fundamentals and talk about the elements of 647F. The first is that you have to be found in a public place, which is already kind of a weird element, but we'll go over that a little more in just a second. Further, you have to be under the influence of a drug, liquor, controlled substance. I think toluenes are in there, and all the usual things that you can be under the influence of. And further, one of the 2 following things: either you have to be unable to exercise care for your own safety or the safety of others, or you have to be obstructing or interfering with the use of a public way by reason of being under the influence. So before we could talk about those elements and defending them in particular, let's talk about what definitely doesn't work. One of the more useful things you can do when you're first learning about a new statute or new area of the law is seeing who's been trying to plow roads before you, and who's done stuff that you can eliminate as a possible defense. First thing, 8th Amendment defense, based on, basically it's cruel and unusual to punish my homeless alcoholic client who has basically no free will in the matter for drinking when he's just, living what's essentially his home in a public place. And is addicted to alcohol and doesn't really have a lot of choice in the matter. That is cruel and unusual, perhaps, but not cruel and unusual within the meaning of the 8th Amendment, courts have ruled. And also the same defense, but alleging a lack of mens rea because, my guy has no free will in the matter because he's an alcoholic, does not work. Also doesn't work, you cannot challenge, well, you can, but it won't work. But courts have overruled challenges to vagueness, to constitutional vagueness, over the meanings of terms within the statute. Courts have ruled that through case law and other sources of law, things like public place are more or less perfectly clear. Speaking of that, rather, let's start with that and challenging the public place element. So I've divided this section up into talking about both non-residential areas and residential areas, because the analysis is a little bit different depending on where you're near a house or an apartment, or when you're near a more public quote-unquote place like a commercial building or a business. So we'll start with non-residential areas. In a non-residential area, public place basically means a place, quote, open to common or general use or visible to the public. The thing to emphasize here is that courts don't have like a lot of hard and fast rules here, and that courts acknowledge that everywhere is different. Some places are more public than others. Some places have quirks in their layouts. Some places may be more or less, private by nature. And so courts are going to analyze this on a case-by-case basis rather than try and set down hard and fast rules. But that said, there are some guidelines that are fairly predictive of whether a place is going to be public or not. In a business, you will be in a public place if you're anywhere a customer can go, or anywhere a customer can see from anywhere they can go. So my example here is if you're behind the counter and only employees are behind the counter, but you're passed out, drunk, that will not save you because you are somewhere an employee, or not employee, excuse me, a customer can see. But like in the back of a Target or something, for instance, if you're behind the swinging doors and there's a big sign on there that says employees only, you're probably better off. The more hard it is for a member of the public to get into that part of the business, or to see into that part of the business, the better off you will be. One thing to note is that private places in public establishments are public if they're used by the public. So if you go to the ER, for instance, and they take you back and they put you in your little room, draw the curtain, it seems private. But no, not according to the case law. You are in a public place for the purposes of the statute. As you can imagine, ER rooms are a rather interesting place to find someone under the influence, and sometimes cops are poking around in ER rooms, and sometimes they find people intoxicated there. So if you are in such a place, and it's not just ER rooms, I put a massage parlor hypothetical in here, anywhere that might seem private, if it's in a public establishment and it's used by customers, even if it's only used by a particular customer at a time for the sake of, quote unquote privacy, it's still going to be a public place. And lastly, we'll talk about cars. As with the Fourth Amendment, cars are not super useful here. Basically, the way I analyze if the client is in a car is I just take the car away entirely and ask myself whether or not the client would have been in a public place if they had been just sitting or standing in that same spot. Cars don't add any additional privacy, which is a little counterintuitive, but that's the law. All right, so on to residential areas. Houses. When are you in a public place? When you're in a house. Usually you're in a public place if you're somewhere the public would be able to go unchallenged, even if that's your private property. So the front lawn, for instance, or driveways are the prototypical example. It might be your own house, might be yours, bought and paid for in your name. You've paid down the mortgage. It's your private property by right, and so on and so forth. But nevertheless, if a member of the public would be likely to be able to go there unchallenged, it is a public place for the purposes of this statute. But if you're somewhere where a member of the public would not be able to go unchallenged, such as a fenced backyard, most commonly, but also a fenced front yard if you have that. Obviously, anywhere in the house counts. If you have like an outhouse on rural properties, that will probably count. Then you're not in a public place anymore. You are in a private location. And the site is worth mentioning here. It's People v. White, 278 Cal Reporter 48. That's a good site to remember because it's what you want to cite to the judge or the finder of fact if you're in trial for a jury instruction or something, to talk about this wasn't a public place because the public couldn't really see into it through the fence or whatever. Again, it's a little case by case, and there are no hard and fast rules. It's more guidelines, but generally anywhere, the more difficult it is for a member of the public to access a location, the more likely it is to be private, and the more difficult it is for a member of the public to see into the location, the more likely it is to be private. For common residential areas like apartment buildings, condo squares or whatever, if there are common areas like a common room or a laundry room or something, and the public can just walk right in and go into that laundry room without anything stopping them, you're probably in a public place because any random member of the community, the apartment or whatever, can go in there. But it's not really clear what happens if the whole apartment complex, for instance, has a gate that you have to know the code for or something, and then once you get by that gate and then you go into the laundry room, is that a public place or not? It's a little bit of a tougher call. My guess is that courts would probably say it is, just because other members of the apartment complex might be there or whatever. But if there is some controlled access, or is there some difficulty seeing or getting in there for a member of the public, I would at least litigate it. All right, so let's talk about what found in a public place means, because it's not just you have to be in a public place, you have to be found in a public place. And here we have a situation where the exact meaning is very relevant. So there's no mens rea defense. Intent to be in the public place does not matter. That's not where the intent part of this crime exists. The intent applies to the intoxication part, not to the being in a public place part. The Olson case, which is a site here, is worth mentioning because it's very helpful in understanding what we mean here. So in Olson, there was a guy who got drunk at a lady's house that he knew, and the lady, perhaps unsurprisingly, decided she didn't want to have the drunk guy, the belligerent, probably drunk guy in her house anymore. So she kicked him out. She made him leave. Whereupon he was immediately found by the police and arrested for 647F. And his defense was, well, look, I didn't have any intent to be in a public place. It was my choice. She kicked me out. I never intended to, I thought I was going to be able to sit there and drink peacefully in private, and it turns out that does not matter. The intent applies to the intoxication part, not to the public place part. You just have to be found in a public place. But found in a public place, that matters. Not just be in a public place, found in a public place. So if the police find you somewhere private, for instance, and then take you somewhere public, even as part of a consensual encounter where you agree to go with them of your own free will, you're still not guilty of public intoxication under 647F because you weren't found in the public place. They found you in the private place and then took you to the public place. So the spot where police initially locate you seems to matter. Now, I don't know whether it has to be police. Like, for instance, if you're drunk in a store and the store manager fines you, I don't think that issue's been litigated, but litigate it. That one's pretty straightforward. But just remember, it matters where you're found. And certainly, you should argue that it has to be the law enforcement officer. And you can sort of cite this case, David W., for that proposition, but I don't think it really stands for that in particular. It just emphasizes the found part. So challenging the under the influence part, this is probably pretty familiar to any criminal lawyer with much experience. It's a little different here than it is in other statutes you might be familiar with under the influence arguments we'll talk about a little bit. You usually don't challenge here because remember there's that other element of whether or not they're unable to care for themselves or others. And so that's usually where the argument happens, not on whether they're under the influence. And usually there's not much of an evidence problem here if the case was filed on. The only thing to look out for here is medical evidence. Police and prosecutors are not trained medical professionals or mental health professionals, and there is often a tendency to conflate health problems, including mental health problems, with intoxication. So look into your client's health at the time the 647F happened. And the most vulnerable ones are going to be the people who are homeless, and they could be suffering from liver failure or something, or be mentally ill, and they'd have no idea because they'd never seen treatment for it, right? So you want to look out for this and be aware that just because your client's found stumbling around, they might smell bad. The officer might have pro forma written, oh, that was the smell of alcohol, but really it was just a bad smell. That doesn't necessarily mean they're drunk. It might be something else that's causing them to stumble around. Look into it. Be observant. Watch your client. Otherwise, it's basically the same as under the influence in other contexts, such as under the influence of a controlled substance or DUI. But keep in mind, again, that you have that other element of not only they have to be under the influence, they have to be so under the influence that they're unable to care for self or others, and that's a stronger element. So usually, if you're going to fight this, you want to fight element 3, unable to care for self or others, first. The only reason you wouldn't fight that is if for element 3 they were using the other half of that element where they were obstructing a public way. But again, that's sort of obscure. Normally you'll be arguing about whether or not they are unable to care for themselves or others. Speaking of which, let's talk about this. This is where the money happens in this context. This is where cases are usually fought. This is usually the elements that is in dispute. It'll usually come down to the cop's observations. But again, remember that very often the cop will think, oh, I just have to, talk about how he failed field sobriety tests and his eyes were watery and he maybe stumbled a little. This isn't just under the influence. This is so drunk that you're unable to care for yourself. It's way stronger in most cases than DUI. You could prove someone has a .15 in this, but that doesn't prove that they're so drunk they're unable to care for themselves. It might prove that they're so drunk they're unable to drive safely, but that those are two different things. So yeah, again, have to prove that they're unable to care for themselves. Usually juries will convict if the cop says anything that could be risky, like, oh, they were staggering around. Well, then the prosecutor will say on close they might have fallen over and cracked their skull right open or something. I have seen people argue that a homeless guy drunk who's sleeping under a bench is unable to care for himself because he's sleeping in an exposed area. That is kind of depressing to me, especially because that's probably something he was going to do, drunk or not. But it can work. Anytime your client is going to be boisterous or hostile and borderline resisting the officer, that's obviously going to probably lose you the case. Anytime they're violent at all is probably going to lose you the case. Anything where your client is really, really drunk, but is otherwise has no signs, like let's say your client has like a .45 blood alcohol content and is just asleep doing nothing, but is in a public place, that's probably, that's enough. Anyone .45 is probably going to lose. And finally, if you are behind the wheel of a parked automobile, even if the keys are nowhere near, you are probably a danger to yourself or others just by virtue of being in the driver's seat. And keep in mind that even someone sleeping in a car might be probable cause to believe that there's a 647F issue if you're running a 1538, usually on a DUI or something. But that's another topic. All right. The other thing to look for is cross-cutting facts. Can you prove that the client did something that proved that they were able to care for themselves or others, or did care for themselves or others. We had a case recently where the client was arguing with the police officer while drunk, allegedly, about the well-being of a family member. In fact, that client had come to the police station to argue with the police about the well-being of a family member that was in custody. And so argument was probably the person got arrested just because they were annoying the cop about it. But our argument was that, well, how can you say he's unable to care for himself or others? He's there to care for others. You know, he even had someone else drive him. And so defenses like that can work. And also keep in mind defenses that you'd use on things like DUI, like the rising falling defense, apply here too. You might be able to say, well, when the officer found him, or when, you know, later when they did the test, he might have been a 0.18, but earlier when he was found in a public place, his blood alcohol content might have been 0.06, and he might have been a lot less, you know, dangerous to himself or others. Obstructing a public way is not super common. This is an alternative to proving that they're unable to care for themselves or others. You usually don't see it a lot because if someone is, laying down in a highway, that's pretty good proof by itself that they're unable to care for themselves or others. One thing to keep in mind is that any public way works, so sidewalks, roads, freeways, dirt path through a public park, things like that. They have to be an inconvenience to some hypothetical person. Actual obstruction is not required, so even if no one has walked in that park for 50 years, if they were laying down there all by themselves and no one was within a 10-mile radius until the cops showed up, they're still obstructing the public way. It doesn't matter if no one actually tried to step over them or whatever. And keep in mind that they must be obstructing it by reason of their intoxication and not for some other reason. I've never seen that litigated. I don't really know what that would look like. I mean, maybe you have a situation where, I don't know, someone's taking part in a protest and they intentionally block a public way for the protest, but they're also intoxicated, and then they try to argue that, no, I was blocking the public way for political reasons or whatever. But I haven't seen that. Okay, so we get to the last tip before I get to the super secret 647G defense. We're going to talk about interaction with Penal Code 148, which is delaying, obstructing, resisting a police officer. So in the counties that I originate from, my law practice originates from Southern California, specifically San Diego, Orange, LA, Riverside, and San Bernardino counties primarily. And not until I came to Tulare did I see this charged much, but here we have often resisting a peace officer and public intox charged in combination. And so is resisting a police officer by itself, which is another thing I don't like, but again, different MCLE there. The point is that there is a mens rea defense here. Penal Code 148 requires willful resistance, obstruction, or delay, while 647F requires you to be bombed out of your mind, basically. And so you can see the contradiction. It's not a contradiction as a matter of law. There's no case saying, as a matter of law, these two contradict each other. But it's, the problem here is really obvious. How can your resistance be willful if you were super bombed? And or how could you have been so bombed that you're unable to care for yourself if you're able to formulate the requisite intent for 148? Normally you want to attack the 148. That's usually going to be the more serious charge, just because crimes against police officers are so unpopular and tend to carry heavier punishments. But you know your judge and you know your locale better than I do, so use your discretion and your judgment, but usually you want to get rid of the 148. And usually that's going to be the more persuasive thing anyway. You're going to say, well, they were so drunk. It's a little harder to say, well, they were so willfully resisting, so how could they be that drunk? It's a little more persuasive to say it the other way around. Okay, so now we get to the fun part. This is the secret weapon that I want you all to take with you. I want you to distribute this to the jurisdiction where you work, to the county where you work here in California, and I want 647G to just completely wipe out the existence of 647F from the face of the earth. So let's go over the text of Penal Code 647G, which immediately follows 647F. So here we go. If a person has violated subdivision F, which is the public intox statute, a peace officer, if she's reasonably able to do so, shall place the person or cause her to be placed in civil protective custody. The person shall be taken to a facility, which is designated in the Welfare and Institutions Code, for 72-hour treatment and evaluation of inebriates. And then blah, 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 blah. We get to the money part. A person who has been placed in civil protective custody in this way shall not thereafter be subject to any criminal prosecution or juvenile court proceeding based on the facts giving rise to this placement. So basically, 647G says if you have someone who's guilty of public intox, cops, you have to take them to the 72-hour drunk take facility of this kind we've specifically provided. And when you do that, that precludes prosecution. There are exceptions. Number one, does not apply to anyone who is under the influence of any drug or in the combined influence of liquor and drugs. So this is only for people who are drunk on alcohol, or something other than a drug, basically. Although what would that be besides alcohol? I don't know. But basically, for all intents and purposes, this means the person has to be drunk on solely alcohol, no drugs. Number two, a person who a peace officer has, and then don't worry about the rest of the text, but you can basically think of this element as if the person's charged with anything else besides the 647F. If the peace officer believed they were guilty of literally anything else other than the public intox, this does not apply. So this applies only to cases where 647F is charged by itself. And three, a person who a peace officer in good faith believes will attempt to escape or be unreasonably difficult. So if they're violent or resisting or escaping or really belligerent, this 647G doesn't apply. So where does this come from? It used to be 647 subdivision FF. It's from 1971. It was to treat drunks and avoid impacting jails and the judicial process with tons of relatively harmless drunks who could just be taken for treatment and cooled off for 3 days in the drunk tank, maybe get some brief de minimis counseling or something, and that way would avoid having to haul these people into court and into jail and spending a bunch of money on litigating their cases. And this, of course, definitely led to a revolution in how law enforcement deals with this crime. Now we routinely take them for super effective treatment to a series of statewide facilities that the legislature budgeted for. And now we never have to convict almost anyone of 647F, except, of course, that's a total lie. The statute totally, no one ever, it was forgotten about almost as soon as it was passed because it seemed to be a little bit non-mandatory. And no one knows it exists. You probably didn't know it existed. I didn't know it existed until I actually only ran across it because in my first year as a lawyer, I was just reading through the penal code like front to back, and I came across it and I go, oh, that's interesting. And then I researched it and found that it had some history, but it's most people don't know it exists. Cops don't know it exists. Prosecutors don't know it exists. Most of the defense bar doesn't know it exists. Judges don't know it exists. So what does that mean? So it says anyone who is taken into civil protective custody can't be prosecuted, but what happens if they aren't taken into civil protective custody because no one knows this exists and cops have no idea that they're supposedly required to do this? So the first to talk about this was LA Superior Court. They said that if you fail to comply, that creates an affirmative defense. The defense has to raise it, but the prosecution, once the defense is raised, has to provide evidence as to why you didn't comply with G. And G says that its whole purpose is to preclude prosecution. So if the defense wins the argument, the prosecution can't provide evidence as to good cause, then the proper remedy is dismissal. But how can we win this argument given the weak text? It says, quote, a peace officer, if he or she is reasonably able to do so, shall place the person. And you can see the easy out for most officers, right? They're going to say, oh, it was a long drive. Oh, I had an emergency call to go to right there. Oh, he was slightly belligerent, da-da-da-da-da-da-da. And they're going to weasel out of it pretty well. And indeed, in this area, anyway, we don't even have any facilities. They'd have to go out of county. So you can see it'd be pretty difficult. But it turns out that there's case law from 2016 which says if the police don't know about 647G, if they don't know it exists, basically, and you can prove that, your client wins. Your client's not guilty. Jorge D is the case here, 246 Calop 4th, 363. That confirms the reasoning in the Ambellas case, which I just talked about, the LA Appellate Department's case. And it lays out a strategy you can copy for winning these cases. So in Jorge D, which is a juvenile case, the police arrest this juvenile, and they just arrest him, and they don't try to take him to the drunk tank because, of course they didn't. They don't know it exists. So counsel in that case cross-examined the officer and got the officer to admit that they didn't even try to evaluate whether he was reasonably able to take the juvenile defendant, to an appropriate facility, because he had never been trained on it and he had no idea it existed. And what Jorge D says is that that means the defense wins, and it's not guilty, and you're entitled to a dismissal, because the G statute demands that the police at least try to make a determination about whether they're reasonably able to take the defendant to a suitable facility. And if they don't do that because they don't know it exists, the defense is entitled to a dismissal. And it's going to be really hard if you get into a factual argument about reasonable ability, because cops are always going to be able to say something like, oh, it's too far away, blah, blah, blah. The stuff I was saying earlier. I've had this emergency call to go to. They'll always have endless excuses. But in cases where you can prove that the police aren't even trying to comply because they have no idea they're supposed to do this, you can win that. So how does that look like? Step one, make sure that your guy doesn't have drugs, doesn't have other crimes, and wasn't super belligerent, escapee, or violent. You might be able to still win even with these disqualifiers if the police are clueless, because your argument is, well, they didn't even know they were supposed to evaluate these factors, so it doesn't matter that, he was also charged with 148 or whatever. But that's unclear whether or not that argument works. Just keep in mind it should definitely work if they don't have those disqualifiers. Step two is you want to set a trial immediately. Do a bench trial, because you don't need a jury for this. The only reason you would not do a bench trial is if you wanted to litigate some other defense to the 647. Like if you're also saying he wasn't a danger to himself or others, then sure, get a jury if you feel like you need one. But you don't need a jury here, and it's sort of a technical legal argument, and you're going to be making it to the judge anyway, so why burn a panel on the jury? Do not file a pretrial motion. Do not tip this off at all before the trial itself. The statute demands that the person be in violation of 647F, and that means apparently that you can't seek relief until the trial, when the prosecution has rested their case. Don't warn the prosecutor or police about this, which is part of why you don't want to file a pretrial motion, because I guarantee you the instant you do that, you'll find the police magically knows about 647G all of a sudden, and in fact did make a reasonable determination about whether or not they were able to take them to some treatment facility, and gosh darn it, I just couldn't. It was just too hard. So don't tip them off. Don't let them know it's coming. Then you make the case look like Jorge D, which we just talked about. You cross-examine the cop to prove that they didn't evaluate whether they could have taken the client to the suitable facility, and preferably that they have no idea what that statute even is. And then at the close of the prosecution's case, you move for dismissal under 1118.1 or 1118 for bench trial, Welfare Institutions Code 71.1 for juvie cases, and then you cite the 647G statute, the Ambellis case, the Jorge D case. The prosecutor almost certainly will try to reopen as soon as they realize what you've done, so they can coach the cop back through and remedy their testimony. Don't let them do that. As soon as you cross, they get one chance to rehabilitate through redirect, and if they fail to do it, which they will because they won't know what the hell you're talking about, don't let them go research it for an hour and then try again. They don't get to do that. And then you appeal it if your dismissal motion is not granted. We haven't really had to appeal it here. The judges have basically grudgingly gone along with our argument, but appeal it if you have a judge who's curmudgeonly or doesn't understand what you're trying to do. So the tricky thing in all that is when I said cross-examine the officer to get them to admit they don't know what you're talking about. How can I do that? Well, number one, you should have the element of surprise if you didn't tip them off. And number two, you're a canny lawyer who has a bunch of tricks up your sleeve, and I'm going to give you some more of them. So first, you want to misdirect the officer and the prosecution into thinking that you're running the typical defense here, which is that the client was a danger to themselves or others. By talking about, well, how drunk were they? Did you consider taking them to a drunk tank? So they weren't that drunk if you didn't take them to a drunk tank. Questions like that. Don't answer questions about where this is going because you don't want to tell them. This is where your trust with a particular judge is going to come in big for you. If you're forced to, then talk about 647G, but otherwise just, I'll tie it up, Judge. I'll tie it up. I'll get there. Eventually, you do need to get to the specifics of 647G. You need to not make it dramatic, and you need to not make it, table pounding and a big deal. You need to make it natural and easy for the officer to admit that they don't know what they're talking about. Like, oh, you didn't take him to a drunk take? You don't know of any requirements that you have to take him to a drunk take, right? And the officer like, no, of course not. Otherwise, I'd do that because I'm so professional, right? You make it easy for them. You make them look like the good guy in all this, so that they go along with it and admit, oh yeah, I've never received any training on anything like that. That sounds weird to me. Yeah. You make it real easy, make it real smooth. Don't try to paint them as the bad guy. Try to paint them as the good guy, and that's perfectly natural that they wouldn't know any of this. Don't Perry Mason it is the way I've put it there. You do need to specifically mention 647G and ask whether the officer is aware of that particular statute and its requirements, and whether they made a reasonable an evaluation of their reasonable ability to do the stuff that statute says. But first, you tighten the net. First, you say you didn't take him to the drunk tank, and you did that. You didn't do that because you don't have any requirement that you have to, right? And so then, thus, you must not be familiar with Penal Code Section 647G, right? You don't know what that statute is. You don't know that it requires you to take the guy to a drunk tank if you make an evaluation of your ability to do so, and you didn't make such an evaluation because you didn't know the statute existed, right? And then they can't answer anything but yes, once you've gotten them to admit that they didn't know of any such requirement before you go into the specifics. So a little bit about the future of the defense. If we win enough cases this way, won't they just figure it out and just start saying they know about G, and in every situation just go, but, blah, 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 emergency call, blah, 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 it would be hard, it's 20 miles away, whatever. Yes, but law enforcement is, of course, extremely slow to adapt to changes like this because they're very busy. With lawyers, we hear of a new legal thing that's interesting. We tell everyone. Cops don't do this until they, as far as I can tell, it's different from department to department, but they learn very slowly when they get busted on technical legal stuff like this. At least some of the departments around here do. But even once they figure this out, then we can start litigating that harder battle of, well, it was a 15 miles away, officer. That's not that far, right? We can start arguing that at that point. And maybe if we bust enough of them on this and get a bunch of not guilties, then the prosecutors will start thinking, oh God, it's another lone 647F filing. Like, do I really want to do this? It's just a 647F. Maybe I should just not file it. And if you're really, really naive and hopeless, you might think, oh, well, this will create, therefore, political pressure for people to build these wonderful treatment facilities that 647G talks about, and get them some treatment and help and make a nice, shinier, happier society for us all. So thank you for it. That's it. I'm not going to show the credits slide in this one, since it has the name of particular lawyers in my office who helped me on this. But thanks to them, they know who they are. And thank you for watching, and I hope this helps you out in your practice.